The federal law banning firearms dealers from selling handguns to adults under the age of 21 has been ruled unconstitutional. Coming from the District Court Judge Robert Payne out of Richmond, Virginia, he wrote that the federal law violates the Second Amendment. And if his opinion is not overturned, that means that gun dealers are now allowed to sell handguns to 18, 19, and 20-year-olds. And this is the ruling. You can see it is a doozy 71-page opinion. We'll hit the highlights. It is out of the Eastern District of Virginia. You see, the case is John Corey Frazier as the plaintiff suing ATF, and this is a memorandum opinion coming out from the judge. He says, for the reasons that I'm going to explain below, guess what? ATF's motion to dismiss, they don't want this lawsuit to go forward, is denied, and the plaintiff's, John Corey, the person who's filing against the ATF, his motion for summary judgment is granted, meaning he wins this case. Here's the background. The plaintiff, the person suing the ATF, is named John Corey Frazier. Also, somebody named Joshua McCoy, Tyler McGrath, Shackley, they're all called the plaintiffs. Young men, it looks like, who want to buy handguns. All four men are over the age of 18, but they're under 21. The first amended complaint details this, but federal law prohibits them from purchasing handguns from federal dealers. Why? Their age. They're all law-abiding, responsible adult citizens. They're all otherwise qualified to own a handgun. They're all adults. They're all over the age of 18. But for the laws here, they would purchase a new handgun and ammunition from a federally licensed firearm dealer if they were of age. Everything except their age allows them to go get one. So in May 2022, Frazier attempted to purchase a Glock 19X handgun. Nice. Because of Frazier's age and in accordance with federal law, the FFL refused to allow his purchase. The other three plaintiffs also wanted to purchase the same thing, but have not attempted to make a purchase due to their belief that it would be futile. They can't do it. They know you're going to get rejected because their friend got rejected. Now they're suing the federal laws. They say they violate the Second Amendment and the Due Process Clause of the Fifth Amendment, and they're suing for everybody else who has been denied access. Now, they are challenging the constitutionality of an interlocking collection of federal laws and regulations that have been concocted to prevent 18, 19, and 20-year-olds from purchasing firearms. They detail what those are for us. Section 922, B1, and we've got 1983. There was another provision. But in sum, when you add them all up, they preclude the sale to previously underaged adult plaintiffs. Anyone aged 18 to 20 is prohibited from purchasing a handgun, and it is a blanket age-based restriction. The government doesn't even pretend otherwise. So let's talk about these issues. They say obviously about standing. So the judge is writing after giving us this background saying, hey, there is standing here. The ATF says these young men, they don't have any standing to sue us. There's no injury here. They're not allowed to do this. But the judge disagrees. It is beyond question that the deprivation of a right conferred by the Constitution is an injury. ATF said they're not even injured. They're 18, 21, 19, 20. They don't need guns and they're not injured. In fact, 3 of them never even tried to get a gun, so they haven't even suffered an injury. And the fact that they haven't gotten a handgun doesn't amount to a recognizable injury anyways. But the judge says that's nonsense. The Constitution says otherwise. So if, as they allege, these young men have a right under the Second Amendment to buy handguns, and if the challenge laws and regulations infringe that right, well, they're injured. It is of no moment that a parent, as a matter of grace, might help them to skirt the rules. So it sounds like the ATF said, well, their parents can go help them get guns. Doesn't matter. These men had their rights violated. The government argument assumes that requiring an adult law-abiding citizen to exercise their right through a third party is not an infringement, but that's obviously nonsense. The government is trying to downplay the significance of this infringement. Rather surprisingly, the judge says, the government alternatively suggests that the plaintiffs lack standing to challenge the laws. But that concept is not implicated in this case, and there are other decisions that support our position that they have in fact been injured. The judge talks about the Second Amendment. To be clear, he reiterates what it says. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. He's referencing the U.S. Constitution and the Supreme Court case in Heller. He's saying the Supreme Court recognized that the Second and the 14th Amendments protect the rights of ordinary law-abiding citizens to possess a handgun in the home for self-defense. That's the law. The Supreme Court also held in Bruin, consistent with Heller and McDonald, that the Second and the 14th Amendment protect an individual's right to carry a handgun for self-defense outside the home, inside the home, and outside the home. And for today's case, Bruin also clarified the proper framework for analyzing alleged violations of the Second Amendment. Here's the standard. If a government bureaucrat tries to do something that impacts guns, how do we measure it? How do we put it in a little canister and say that law's good, that law's bad? Here's what the judge writes. Bruin gives us a framework, saying we reiterate that the standard for applying the Second Amendment is as follows. These are the mechanics, these are the rules. When the Second Amendment's plain text covers an individual conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the historic tradition of firearm regulation. So we default towards a presumption that if it's covered by the Second Amendment, it's protected by the Second Amendment. That's the starting point. And if the government wants to limit it, they've got to show that in American history, there was a tradition of regulating that type of conduct. Only then may a court conclude that the individual's conduct falls outside of the Second Amendment, outside of its unqualified demand. So now, fast forwarding through what we're going to see, if we are a young man under age 21, 18, 19, 20, we're looking back at American history and we're saying, did the founders have a history and a tradition of regulating firearms for 18, 19, and 20-year-old men or women, anybody of that particular age? Is it in the tradition? Because if it is, then that is the only way that we can say that that was appropriate as a limitation on the Second Amendment, if it was done historically. In other words, Bruin requires two steps. One, we look at the Second Amendment. What does the plain text say? If it protects that conduct, it protects the conduct. If it is protected, then we go back and we ask, was it in our history? If it was, then they must affirmatively prove that the regulation is part of the tradition that limits the bounds of the Second Amendment. And courts are limited in how they can interpret some of this stuff. So when we ask ourselves that question, are federal regulations now that limit a person's ability to buy a gun based on age, are those consistent with the historical tradition? Let's look. In the Second Amendment context, that necessitates an examination of evidence from around 1791, when the Second Amendment was adopted. Rewind the clock all the way back. And when evaluating the scope of the right, when they passed this, the court must be wary of historical evidence that long predates 1791 and guard against the given post-enactment history that can bear more weight. In other words, the strongest evidence concerning the scope of the right here comes from the late 18th and early 19th centuries. We're winding back to when this was enacted. And so to uphold its burden, they must show some sort of connection, analogous restrictions historically. So they give us the first step here. They're just going to apply the analysis. In Bruin, we're asking about whether the prohibited conduct falls within the Second Amendment. Seems like a pretty easy answer on that one. The right to keep arms includes the right to purchase arms. You can't keep an arm if you can't buy one. And so here, these young individuals want to go and buy a firearm. That seems like they are being limited from doing that. Common sense logic tells us unless one is the maker of a gun, then they're not going to be able to get a gun unless they can buy a gun. The Second Amendment uses the word infringed, and that includes the right to purchase. So the fact that they can't go buy a gun is an actual infringement on their rights. They do some more analysis between the different circuits. But now we get to the interesting question. Who are the people that are defined in the Second Amendment? Does that include 18, 19, and 21-year-olds? The Second Amendment protects, the judge writes, the right of the people to keep and bear arms. But who are they? These men say that law-abiding citizens who are 18 and older fall within the people. They're law-abiding adults. They're within the body politic. They're within the political community. They count. There are also some people who've hit the age of majority. They fall within the people. 18 is the age of majority. But the government says, well, no, if you're under the age of 21, you're not really the people within the meaning of the Second Amendment. And although the Supreme Court has not really defined that phrase, the people, in the Second Amendment, it has given us some guidance in the Constitution. It is said that the people are protected by the Fourth, the first, the second. The people are part of a national community that have developed sufficient connection with the community, saying that taken as a whole, the people comprise all members of the political community. And that, the judge is going to say, is 18, 19, and 20-year-olds. Going to ask ourselves, what is the political community and how is this created? Lots of analysis here, lots of law that we'll fast forward through. Says, okay, here's where he gets to the conclusion. He says, the analysis now turns to today. Are 18 to 20-year-olds members of the political community today? The text of the Constitution does little to guide the inquiry because it doesn't mention age in the Second Amendment. The founders made reference to the Constitution and age. They did so. They put age for presidency and male voting citizens, granting the right to vote to all citizens over the age of 18. We know that the founders used age to regulate access to important rights, like to vote. They chose not to circumscribe, to limit Second Amendment rights at all. They limited voting to age 18 in a recent amendment, but they didn't do that for the Second Amendment, saying that it's probative of their intent as to the age limit or the lack thereof. In other words, they didn't put an age limit in there for a reason. So he says, let's look to the Constitution. It is true that the age of 18 is arbitrary to determine adulthood. Today, many of the rights and responsibilities that apply to people start at age 18. Some privileges are denied, like drinking. Much to the consternation of college students across the country, the drinking age remains 21. But those differences are distinguishable. There's no similar constitutional right to alcohol or to tobacco. There is a right to possess a firearm, but not to alcohol. And so that's how we can distinguish those out. Says, like other rights, the Second Amendment, like all of them, the other ones, also apply to 18 to 20-year-olds. And saying that there were no previous prior prohibitions in American history and American tradition that would have limited this. Saying, having determined that the conduct in question, purchasing, is covered by the Second Amendment, is there an ability to limit them? The government would have to affirmatively prove the limitations. The judge says, nope, the government has not met their burden. Not all history is created equally. It says we now have to look at the various laws that limited guns. The militia laws in this country do not support a finding prohibiting handguns by individuals. The government has tried to point out that the age of 21 was the standard for militia service, but that's not what the sources say. The government says age 21 is when you join the militia. The judge says no. At the time surrounding the ratification of the Second Amendment, 16 or 18 was the age of majority for militia service throughout the nation. Look at my exhibits, my references here. The government cited various statutes that also don't hold support. In the 5 years before 1789, only 2 states altered their age of militia. In 1785, Virginia joined the minority, moved the age from 16 to 18. Vermont passed the last pre-ratification laws, establishing 16 as the date of militia, 4 years before the ratification of the Second Amendment. Congress in every state in the Union passed a militia law requiring almost all able-bodied white men between the ages of 18 and 45 to serve in the militia. Here's what the act said. So historically, they were requiring young people to be involved, not limiting them. And so America has no history of limitations. And so as we fast forward and continue throughout the opinion, we see the judge is going to reach his conclusion where he says the following: because the statutes and regulations in question are not consistent with our nation's history and tradition, they cannot stand. These young men also challenge these regulations on equal protection grounds, but we do not need to get there because we've already decided them on other constitutional underpinnings. And so for the foregoing reasons, the defendant's motion to dismiss, which comes from the government, is denied. But these young men's request for summary judgment, meaning we don't want any trial on this, we just want to win this right here and now, is granted because the federal prohibitions on limiting 18, 19, and 20-year-olds from purchasing firearms is unconstitutional. It infringes upon the Second Amendment, and it does so without any justification in doing so because in American tradition, there has not been a history of disenfranchising firearm possession for 18, 19, and 20-year-olds. In fact, quite the opposite. There was mandatory militia participation starting at age 18. You need a gun to do that. So the ATF, not going to be happy about this ruling, will very likely see an appeal on this. I'm almost certain of it. and this will continue to work its way up through the various circuits. This one's coming out of Virginia. There will be other rulings on this, and at some point, the Supreme Court will have to clarify, what does we the people mean? What is appropriate in terms of age limitations for the possession of firearms? And of course, we will continue to cover. Thank you for subscribing, and we'll look forward to seeing you on the next one.